Dear viewers, welcome to yet another episode on Course of Property Law. I am Dr. Shivani Verma from Law Center 1, Faculty of Law, University of Delhi. Today we are going to discuss the topic Religious and Cultural Foundation of Private Property. Private property is a privilege derived from a rule of a system that establishes that in case of an object, the person whose name is attached to that object must determine how the object is to be used. It is his and only his prerogative to determine the usage of the property that he owns and possesses. In 1978, the 44th Constitutional Amendment changed the fundamental right of property and converted it to a constitutional right under Article 300A. And later in 1995, in the case of Jilubai Nanbai, Kochar, it was held not to be part of the basic structure of the Constitution and once again reiterated property to be a mere legal right. The court have time and again asserted that the doctrine of eminent domain permits the state to acquire the private property, but only for the public purpose, non-arbitrarily, and after paying a fair and equitable compensation. Supreme Court, while discussing such acquisitions by the state, clearly upheld the sanctity of the right to private properties and the legal protection attached thereto by calling right to property a human right. In the year 2020, Supreme Court in the matter of Vidya Devi versus State of Himachal Pradesh said that doctrine of adverse possession cannot be used to establish a title over an acquired private property if the acquisition was not duly done. The Honorable Court observed that it is only in compliance with the procedure established by law that the state can dispossess any citizen of his property. The obligation to pay compensation can be inferred fairly from the language of Article 300A, and hence forcible dispossession of a private property of a person without a due process of law and without due compensation must be construed as violation of human right and constitutional right as propounded under Article 300A. However, there is another aspect of private property which cannot be ignored. India is a secular country with diverse cultures and homes people of various religions. This diversity reflects in the idea of property also. Let's understand the cultural and religious foundation of private properties. The cultural foundation of property in India can be found in various forms in Hindu scripts like Mahabharata, Manusmriti, Shukraniti, and other types of Hindu political theories. It is believed that because of man is vicious by nature, the government needs to be coercive sometimes in order to prevail rule of law in the society. And that is why state functions through dand, that is, rule of law by regulated and governing through law, deterrence and penalties. This creates a well-regulated civil society which can only then be called as state. It is in harmony with this concept of mamatva, which is discussed in Matsya Nyaya. Mamatva is mam, that is mine, and tatva, that is object. This is where the concept of property lies, but it is always in correlation of dharma, that is law, justice and duty. Both the property and dharma are the institutions that create a state along with the people. No property exists in a non-state. Matsya Nyaya says that in non-state, people can definitely possess or enjoy, but they cannot own without the fear of it being taken away. Mahabharata establishes that property in essence is a concept that is about owning and yet carefulness about enjoying and possession of it. In India, property is not for bhog, it's mamatva. Bhog and bhay together that creates the concept of property in state. Gita, while talking about righteousness, states that he who works in pursuit of what is right will never trespass, but will always be fearless while protecting that which is rightfully his. It is this that takes courage, but to own the right on any kind over the property or any other kind, the will to fight for that must come. Chanakya, in his Arthashastra in chapter 3.9, clearly recognizes the concept of ownership over the land and other kinds of private property. It clearly lays down two aspects of private property. One, who earns and acquires the property must use it judiciously and to the best for himself and society. Second, king must make sure that such property is protected from seizure and any misuses. Manusmriti also establishes the concept of property in context of private individuals, and accumulation of property is considered to be a strategic concept. The hardworking man deserves and must accumulate property. This property, however, must be inherited by his son only. However, the property of the sonless man can be taken away or taken over by the father and the brothers. Agni Puran also describes how a lawfully gathered property should be divided equally and fairly amongst the sons, and then it must be the duty of the sons to fulfill all of their father's responsibility. However, the benefit of the common property must be divided equally. In Muslims, Quran and Hadith talks about Islamic law in context of property. The concept is again based on justice, fairness and equality. In Islam, property and the concept of ownership is treated as something which is capable to be defined, specifying and then to be owned. The right over such properties are written down in Sharia law. This law also talks about protecting these rights and regulating them. In Islam, Allah is believed to be the ultimate owner. Like everything else, all the land belongs to Him. He has bestowed upon us the treasures of land for us to use freely. But while we own and use this land, we are expected to be fair. In Islam, the ownership signifies owning the property and also the right to transfer this property through legitimate methods. The owner deserves ownership as long as he wants to enjoy and most importantly uses the property productively. This property, in the events when he says to do so or when he is not able to use the property properly or productively, then he can be induced or even forced to give up the right of property that he had. In Christians, Bible also establishes property as that of lords. However, it is also said that the land cannot be shared together, and this is where the concept of private property lies in Bible. It is also laid down in Bible that when someone lives on a land uninterruptedly for a long duration of time, he acquires right on that property. Guru Granth Sahib also does not consider property as an evil concept, but Maya or wealth, including all the types of property, must be held in harmony with the core beliefs of Sikhism, that is, the three daily principles of Sikhi, that is, truthful living, service to humanity and devotion to God. Beyond this, any use of property by it, so owner, is allowed. Personal law and concept of property. Before codification, there were two schools of thoughts governing the concept of property for Hindus, Mitakshara and Dayabhaga. While Mitakshara is based on Janmasvatvada, that is, ownership arising on birth, Dayabhaga is based on Upramasvatvada, that is, ownership on death. Mitakshara school. In Mitakshara school, sons have equal right and ownership on their father's ancestral property. These co-partners come into existence at the time of birth of the son. After 2005 amendment, females can also become co-partners. It is also known as school of survivorship, notional partition and aggregate ownership. As the co-partnership rights depend on birth and death, the quantum or share cannot be decided and depends on the event of life and death. There is always a supplementary principle of propinquity, that is, kinship or degree of closeness in blood. However, the right of these co-partners are limited and they cannot alienate their shares. The school is divided regionally in many further schools like Bombay School, Mithila schools, etc. Second is Daya Bhaga. The co-partnery concept in Daya Bhaga is completely different. It says that a son does not by birth acquire any right in the ancestral property. It is the death of the father that the property devolves by the way of succession to the son. Here it is believed that father has power on his property to dispose it of and alienate it by the way of instruments of will, sale or mortgage, etc. During father's lifetime, a son has no right to seek partition. The school tries to identify the fractions or shares of the co-partners and hence is also called as fractional ownership. The school backs the concept of religious efficacy and the share will pass on to the daughter and or widow of the person. Property in Hindu law is categorized in two kinds, namely joint Hindu family property and separate property. Let's understand each one of these. Joint Hindu family property or co-partnery property as it is called is consisting of ancestral property. The property acquired by the joint family members jointly, separate property of any member which is surrendered in the common stock or pool of the joint family property, and property which is acquired by one or all the co-partners with the aid of the joint family fund. There is another category, unobstructed or obstructed property as per Mitakshara school of property. Joint family property, it is a co-partnery property which has joint interest of every co-partner on it. Also, the property which is acquired jointly with aid and assistance of the ancestral property comes into the ambit of this ancestral property. The court in the matter of V. Dhanvati versus CIT held that the self-acquired property is acquired by oneself without any aid of the joint property, but wherein the property is joint or acquired by a co-partner with the aid of the joint property, it is then called joint family property. And anyone who asserts a property to be a joint family property must bear the burden of proof that the property in question was acquired with the aid of the joint family property. In case of Chaturbhuji versus Brahmbi Naranji, any property that is acquired with an intention to co-own it as part of joint family property will be the joint family property. In case of Bhavar Singh versus Puran, the court clarified that the co-partnery property consists of ancestral property and anyone having share in it, the inheritance will be a co-partner. Self-acquired property. There are two kinds of self-acquired properties, ancestral and separate. Self-acquired is the property which was ancestral, but after partition of joint Hindu property, it is acquired by the owner. Ancestral property flows down to the generations freely. A property to be called an ancestral property, it must flow down and be inherited through 3 generations uninterruptedly. 3 degrees of ancestral history is needed to call a property an ancestral property. Ancestral property is simply the property that is inherited from father, grandfather and great-grandfather. In Uttam Singh versus Subhag Singh, the court read section 4, 8 and 19 of Hindu Succession Act of 1956 and held that ancestral property is based on intestacy. Also, inheritance of ancestral property does not create Hindu undivided property. Next is separate property. Separate property is the kind of property which is acquired or is not inherited from the blood ancestors. Any property which is acquired by any mean other than inheritance falls into the category of separate property. Examples can be property acquired by the way of gift or sale, etc. Then what is obstructed property? The property is called obstructed property when the right over it does not accrue by birth, but on the event of the death of the final owner. The term obstructed is used because the accrual is obstructed by the existence of the final owner and the right activates only on the death of the final owner. Example, if A has a brother B, he can acquire B's property if he dies unmarried without any child. So, A's right is obstructed till B lives his life and remains unmarried without any child. Unobstructed property. This property which an individual secures at the time of his birth is called unobstructed property. Such property is not obstructed by the presence of anyone. Hereditary property which has finally landed onto the final owner now becomes unobstructed property. Muslim law and concept of property. In Islamic law, the idea of succession and property are constituted of four sources: Quran, Sunnah, that is the sacred practice of Prophet Muhammad; Ijma, the consensus of the learned and respected men of the community; Qiyas, interpretation of the principles of Allah to the understanding of right and wrong. The ayahs in Muslim law are either sharers or residuaries. Sharers are those who are entitled to share a property on the event of the owner's death. A few of such sharers are enlisted as husband, wife, daughter, son, daughter of son or son's son, and so on. Father, paternal grandfather, mother, and uterine siblings, etc. On the other hand, the residuaries are the ones who own the property only if it is left after the sharers take over their shares. Kind of succession in Muslim law. There are two types of succession that are possible in Muslim law: non-testamentary and testamentary. Non-testamentary are governed by Muslim Personal Law Shariat Act of 1937. However, the testamentary succession, that is where the will is made, the inheritance is governed by Shariat law as per its applicability for Sunnis and Shias. In Muslim law, a child does not get the right to inherit the property from the time of his birth, but it is a right that gets created when the ancestor dies. If the child does not survive the ancestor, the right of such inheritance never exists. While the share is being distributed, the Sunni law follows per capita method, wherein all get equal share, whereas in Sunni law it is following per strip rule, wherein people in one slab or strip get equal right, which might differ from people falling in any other strip. There is a concept of estate, and when a Muslim dies with no heir, the property are inherited by the government, and the process is called estate. Impact of conversion over the property. India, being a secular country under Article 25 of the Constitution, allows every individual to profess and practice any religion, enabling him to choose the religion they prefer. But such conversion results in applicability of the personal laws in a given case and make the concept of property and rights over it more complex. The Hindu Succession Act of 1956 explicitly or implicitly does not disqualify the Hindus from conversion, but Section 26 of the Act says that the descendants who are born after the conversion will be barred from inheriting any property from their relatives that are Hindus. If these children of converted Hindus choose to become Hindus at the time when choice of succession is open, then the bar won't be applied. While interpreting the applicability of Section 26 of the Hindu Succession Act of 1956 in case of E. Ramesh versus Rajani, it was held that bar is on the descendants of the converter, but if the person converts himself, then there is no such bar. Muslim personal laws are not codified as Hindu laws, but visibly there is no such bar in Shariat to deprive the children of the converted Muslims from inheritance. In the matter of Kunnilal versus Kunwar Govind Kishan Narayan, the Caste Disability Removal Act of 1850 was discussed, and it was held that the act nullifies the provisions that punishes renunciation or exclusion from the caste. But even though the act was repealed, it is still relevant where right is abrogated because of conversion. In few of the other cases, like Narayan Ben Feroz Khan Pathan versus Patel Shanta Ben Bhika Bhai, it was upheld the right of converted daughter over father's property, and in Shabana Khan versus Sulochana, the view was upheld. In Christians and Parsis, the Indian Succession Act of 1925 prevails for the matters of inheritance of property, specifically the matters of intestate and testamentary succession of immovable property. Goa Daman and Diu Administrative Act of 1962 makes Portuguese Civil Code applicable in the state of Goa. As per the Treaty of Cession of 1956, the French Civil Code is still applicable in Pondicherry. In Northeast, customary matriarchal system of the inheritance still exists, and hence the Garos of Meghalaya are not governed by Indian Succession Act of 1925. The religious and cultural foundation of private properties might seem different in all the religions, but one thing that is common is the principle of fairness and involvement of the concept of property in the context of social justice and productive utilization of the resources in the best possible way. State in the cultures and religions is duty bound to safeguard the right to property in order to uphold the principles of ownership irrespective of the religion and belief. So that was all about cultural and religious foundation of the property. Thank you so much.